on Capitol Hill for a Senate hearing on detainee interrogation tactics used during the Bush administration. This is the first public hearing on the issue since the release of Justice Department memos that provided legal advice on the use of waterboarding, sleep deprivation, and other harsh techniques. Sheldon Whitehouse of Rhode Island chairs the Judiciary Subcommittee on Administrative Oversight. This is live coverage on C-SPAN 3.
Good morning. Good morning. The hearing will come to order. I will make some brief opening remarks. The distinguished ranking member.
Acting would be good.
Acting ranking member will make some remarks. Distinguished chairman will make some remarks. Chairman Feinstein will make some remarks. And if anybody else wishes to make some remarks, I'd like to try to get opening remarks closed before the 10:30 vote begins. And then we'll come back and go to the witnesses. I thank everyone for being here. Winston Churchill said, "In wartime, truth is so precious that she should always be attended by a bodyguard of lies." The truth of our country's descent into torture is not precious, it is noxious, it is sordid. But it has also been attended by a bodyguard of lies. This hearing is designed to begin a process that will expose some of those lies, that will prepare us to struggle with that sordid truth, and that will examine the battlements of legal authority erected to defend that truth and its bodyguard of lies. The lies are legion. President Bush told us America does not torture, while authorizing conduct that America has prosecuted, both as crime and war crime, as torture. Vice President Cheney agreed in an interview that waterboarding was like a dunk in the water when it was used as a torture technique by tyrannical regimes from the Spanish Inquisition to Cambodia's killing fields. John Yoo told Esquire magazine that waterboarding was only done 3 times, when public reports now indicate that 2 detainees were waterboarded 83 and 183 times. About Khalid Sheikh Mohammed, reportedly waterboarded 183 times, a former CIA official had told ABC News, "KSM lasted the longest under waterboarding, about 1.5 minutes, but once he broke, it never had to be used again." That, too, was a lie. We were told that waterboarding was determined to be legal, but were not told how badly the law was ignored, bastardized, and manipulated by the Department of Justice's Office of Legal Counsel. Nor were we told how furiously government and military lawyers rejected the defective OLC opinions, but were ignored. We were told we couldn't second guess the brave CIA officers who did this. And now we hear that the program was led by private contractors with a profit motive and no real interrogation experience. Former CIA Director Hayden and former Attorney General Mukasey told a particularly meretricious lie, that the Army Field Manual restrains abuse by naive young soldiers, but isn't needed by the experienced experts at the CIA. The Army Field Manual is a code of honor, as reflected by General Petraeus' May 10, 2000 letter to the troops, which I ask unanimous consent to have admitted as an exhibit to this hearing, without objection. Moreover, military and FBI interrogators such as Matthew Alexander, Steve Kleinman, and Ali Soufan are the true professionals. We know now that the experienced interrogators referenced by Hayden and Mukasey had little to no experience. In fact, the CIA cobbled its program together from techniques used by the SIRI program, designed to prepare captured U.S. military personnel for interrogation by tyrant regimes who torture to generate propaganda. To the proud, experienced, and successful interrogators of the military and the FBI, I believe Judge Mukasey and General Hayden owe an apology. Finally, we were told that torturing detainees was justified by American lives saved as a result of actionable intelligence produced on the waterboard. That is far from clear. Nothing I have seen convinces me this was the case. FBI Director Mueller has said he is unaware of any evidence that waterboarding produced actionable information. The example of Zubaydah providing critical intelligence on Khalid Sheikh Mohammed and Jose Padilla, often given is false, as the information was obtained before waterboarding was even authorized. And there's been no accounting of wild goose chases our national security personnel may have been sent on by false statements made by torture victims just to end the agony. No accounting of intelligence lost if other sources held back from dealing with us after our descent to what Vice President Cheney called the dark side. No accounting of the harm to our national standing or our international goodwill. No accounting of the benefit to our enemies' standing and goodwill, particularly as measured in militant recruitment or fundraising. And no accounting of the impact this program has on information sharing with foreign governments whose laws prohibit the type of treatment and detention policies the administration has enacted. I could relate other lies, a near avalanche of falsehood on the subject of torture and what we've been told about interrogation techniques, but I suffer a disability. I'm a legislator. Legislators have no authority to declassify. Our Senate procedure for declassification is so cumbersome that it has never been used. All of the declassifiers in government are executive branch officials, and the Bush administration knew this, so they spouted their rhetoric, again much of it outright false and much of it misleading. And though many of us in Congress knew it to be false, we could not reply. It is intensely frustrating. We've been told you shouldn't criminalize conduct by prosecuting it. You criminalize conduct by making it a crime under the law of the land at the time the crime was committed. Prosecution doesn't criminalize anything. Prosecution vindicates the law in place at the time based on the facts that are admissible as evidence. We've been told you shouldn't prosecute people who followed lawful orders or relied on proper legal authorities or in good faith offered their best legal advice. But those are the questions, aren't they? And not the answers. This is the first of what I hope will be a series of hearings looking into these questions. I hope we'll soon be provided the Department of Justice Office of Professional Responsibility report on its investigation of the Office of Legal Counsel and hold more thorough hearings in the wake of that. Let me conclude by saying what a very sad day it is for America and for the Department of Justice that there should be such a thing as an OPR investigation into the United States Department of Justice Office of Legal Counsel, and how loathsome it is what a few men did to bring this upon that office. I'd like to thank Chairman Leahy for allowing me to hold this hearing. No one has worked harder and cares more about this issue than he does. I also want to acknowledge the tireless work of Senator Feinstein, my chairman on the Intelligence Committee, who is leading its detailed investigation into the Bush administration's interrogation and detention program. I applaud her for her efforts to get to the bottom of this shameful period of our country's history. Today we will hear from a distinguished panel of witnesses who will help us shed light on this topic. I thank them for their appearance this morning. I remind them all about unauthorized disclosure of classified information. I want to make a particular note about our last witness, Ali Soufan. Mr. Soufan interviewed al-Qaeda terrorists and went undercover against al-Qaeda. Threats against him have been documented. We ask the press to respect the security procedures we have in place and avoid photographing his face. Senator Graham, any statement you would like to give?
Thank you, Mr. Chairman. Well, I really don't know what to say or how to begin other than the difference between the nobility of the law and a political stunt may be soon evident one way or the other, and I don't know whether this is actually pursuing the nobility of the law or political stunt. We'll let the American people decide, but I don't question the chairman's motivation. He's a very fine man, and I think he's rightly disturbed by some of the decisions that were made in the past, and so have I been. But I guess if we're going to talk about evil, we need to talk about it more than just the last administration's policy decisions about trying to protect the nation, or to put in context what we're facing and who we're fighting. People who really could care less about any law anywhere. And would we have this hearing if we were attacked this afternoon? You want to have a bunch more hearings about what happened in the past? If one of our national treasures were attacked tomorrow, would we have more hearings? Or would we focus on repairing the damage and staying ahead of the enemy? If we're going to find out who did what when, we need to find out who was told about it and when they were told about it. And if we're going to really find out what happened, it seems to me we'd want to know what worked and what didn't. So I'm calling today for any memos that show information that was gathered from any enhanced interrogation technique, that be made available to the committee so we could look and see what worked. That's only fair. And you've got to remember, we're talking about this now many years after 9/11, and the people that we're judging woke up one morning like the rest of America and said, oh my God, what's coming next? It's not really fair to sit here in the quiet peace of the moment and put ourselves in such a holier-than-thou position, because you don't have to make that decision. They did. And I've been a criminal lawyer, defense and prosecutor for most of my adult life. I think I know the difference between a policy debate where I may disagree with the conclusion and a crime. The idea that you would read your political opponents into your crime makes no sense. The idea that you would seek advice from all corners of the government in formulating policy and to call that a crime is dangerous. What happened on September 11th, 2001 was unprecedented. It was the most vicious attack on our homeland by a foreign entity in the history of the nation. Mr. Chairman, here's what I think happened. The nation was rattled, the administration went on the offensive, and they looked at some statutes on the book as a way I wouldn't have looked at. They were very aggressive. They were going to make sure this didn't happen again, and they tried to come up with interrogation techniques evaluating the law in a way that I disagree with their evaluation. But there's not one iota of doubt in my mind that they were trying to protect the nation. But they made mistakes. They saw the law many times as a nicety that we couldn't afford, so they took a very aggressive interpretation of what the law would allow. And that came back to bite us. It always does. But that's not a crime. What we have to understand as a nation is that the fact that we embrace the rule of law is a strength, not a weakness. The fact that we will give our enemy a trial and they won't makes us better. The fact that our judgments are rendered based on evidence reviewed by independent judiciary is a strength. Their kangaroo courts are not the model for the world. So I have tried over these many years to speak up in a way that I think is best for the nation. As to the Army Field Manual, I think I have a pretty good understanding of it. I know why it exists. To say that is the only way you can interrogate someone within the law is not right. There should be interrogation techniques not on the internet for our national security. And let's bring the CIA director into this hearing. He has already testified if we caught a high-value target tomorrow, he would go to the president and ask for interrogation techniques not in the Army Field Manual to defend this nation, but they would be lawful. Is he a criminal because he would do that? No. I think this administration's policy, at least through the CIA director's sworn testimony, is that they would reserve unto themselves the ability to brief the commander-in-chief about a high-value target, and they would suggest techniques to the commander-in-chief that were lawful that are not included in the Army Field Manual. So this idea that someone said the Army Field Manual is the only way you can lawfully interrogate somebody, I completely disagree with. And to those who suggest it may not be the best tool available to the country, I totally agree with. Now, I don't know what Nancy Pelosi knew and when she knew it, and I really don't think she's a criminal if she was told about waterboarding and did nothing. But I think it is important to understand that members of Congress allegedly were briefed about these interrogation techniques. And again, it goes back to the idea of what was the administration trying to do. If you're trying to commit a crime, it seems to me that'd be the last thing you'd want to do. If you had in your mind, in your heart, that you're going to disregard the law and you're going to come up with interrogation techniques that you know to be illegal, you would not go around telling people on the other side of the aisle about it. You would not be getting legal advice. And the point of the matter is that they chose to ignore some pretty good legal advice. But is that a crime? So, as we go forward, there's a purpose to everything. There's a reason people do what they do. And it will soon become evident, I think, over time, the reason for these hearings. There's a lot going on in this world today, at home and abroad. And I wonder where this fits into the average American's hierarchy of needs right now. I've been on the Armed Services Committee where we did a very thorough investigation of these interrogation techniques and how they came about. The Levin report is a good one. It's there to be read. I'll take a backseat to no one about my love for the law and the desire for my nation to be a noble nation. The moral high ground in this war is the high ground. It's not a location. The enemy we're fighting, Mr. Chairman, doesn't have a capital to conquer or a navy to sink or an air force to shoot down. It is an ideological struggle, and the decisions made in the past have had two sides. We did get some good information that made us safer, but we also hurt ourselves. We damaged our reputation, and we did some things that I think are not going to make us safer in the long run if we kept doing them. So I'm ready to go forward. Waterboarding has never been an appropriate technique for me, and if there are any military member listening out there today, you will be prosecuted if you waterboard a detainee in your charge. Under the Uniform Code of Military Justice, it would be a violation. As to other agencies, please understand that in 2001, 2, and 3, the Geneva Convention did not apply to the War on Terror, only until 2006. The war crime statute that existed in 2001 was a joke. It codified the common Article 3 standard, which nobody could adhere to because it's so vague in terms of the notice it would give to someone to comply. We have today, I think, the best war crime statute on the books of any nation in the world that would outlaw a grave breach of the Geneva Convention. We passed that in a bipartisan fashion. We have policies now, the Detainee Treatment Act, the McCain Amendment, and other policies that give our people who are fighting this war the guidance they need to make sure they understand what's in bounds and what's not. And we have a new president. Now we'll conclude with this. President Obama, in my opinion, has made some very sound decisions regarding Afghanistan and Iraq. I had a meeting yesterday with the administration about what to do with Gitmo detainees, how we can deal with these detainees in a way that adheres to our values and protects our nation. I want to be on record as saying that I think the administration has taken a very responsible view of Afghanistan, Iraq, and Guantanamo Bay. And it's my belief that they may ask for another continuance regarding military commission trials so that the Congress and the administration can sit down and work out what to do with these detainees as we move forward. If that request is made, I applaud it. I do appreciate what the President is trying to do to repair our image and to create rules for the road as we go forward. But as we look back, I will conclude with this. As we harshly judge those who had to make decisions we don't have to make, please remember this, that what we do in looking back may determine how we move forward. And let's not unnecessarily impede the ability of this country to defend itself against an enemy who is, as I speak, thinking and plotting their way back into America.
Thank you, Senator Graham. Chairman Leahy, and then Chairman Feinstein.
Thank you, Chairman Whitehouse. This is one of the most important hearings the Senate Judiciary Committee will hold this year. I've listened to my friend from South Carolina. I've listened to each of his several conclusions that he made during his opening statement. I also heard him speak of the nobility of the law. I would just urge senators not to raise straw men and try to predetermine this hearing. Let's listen to the witnesses who are going to be testifying rather than raising hypotheses and facts really not in the record. I applaud Chairman Whitehouse for doing this. His own background as an Attorney General, as a U.S. Attorney, makes him eminently suited. I think it's one of the most important hearings we'll have in the Judiciary Committee because it raises the question of how we got to a place where the Department of Justice's Office of Legal Counsel, an office that basically sets the standards for the whole federal government, came to write predetermined and premeditated legal opinions that allowed President Bush to authorize the torture of those in American custody and control. Opinions that had to ignore our own laws, our own international agreements, and our own precedents as a nation. From General George Washington's example during the Revolutionary War to the Civil War, the World Wars, Korea, and Vietnam, it was America that provided the model of a nation that would not engage in such practices. It was America that led the world in the recognition of human dignity and human rights. And I think that the elite legal office at the Justice Department, responsible for guiding the executive branch and with the power to issue binding interpretations of law, so misused its authority, is one of the fundamental breakdowns in the rule of law that dominated during the past 8 years. The recent release of 4 more Office of Legal Counsel memos written by 2 former heads of the OLC, Jay Bybee and Stephen Bradbury, demonstrate in excruciating detail the methods authorized and used on people in American custody. We'll hear all about those, shackling naked people from the ceiling, keeping them inside a small box with insects, beating them repeatedly, waterboarding. These are actions that we rightly protested when they've been used against Americans by other countries. And the purported legal justifications for the policies are disturbing. Some of the opinions use an end justify the means type of circular reasoning, saying that even though we would object if anybody ever did this to an American, it's okay for Americans to do that because we're Americans. It is not reasoning that stands up. Some seek to defend the use of these techniques by relying on hyper-technical interpretations that disregard the prohibitions in our laws. All seem to be poised on the idea that the president is somehow above the law or can override the law. Well, the rule of law in the United States means no one is above the law. None of us as senators, nobody in this room, and not the President of the United States. So Senator Whitehouse deserves applause for having this hearing and for his own commitment to the rule of law and getting to the truth. I'd like to go forward in a nonpartisan commission, as I've said before, but that's going to require support from both sides of the aisle, one that could get to all the truth of what happened. 2 weeks ago, I invited Judge Jay Bybee to testify before the Senate Judiciary Committee. I did so after reading accounts in the Washington Post suggesting he had expressed regrets regarding his work at the OLC. And then in comments he sent a couple of days later to the New York Times, he turned around and defended the same legal opinions. Incidentally, legal opinions have now been withdrawn. I invited him to come forward and tell the truth and the complete truth before the committee. Which Jay Bybee do we rely upon? The one that was in the press one day or the one that was in the press the next day? I asked Mr. Chairman if I could include in the record a copy of that letter to him.
Without objection.
Now, since he's declined through his lawyers to testify before the committee, I assume he has no exonerating information to provide. I wish he would testify for us to help complete the record and find why he refused. It is appropriate in this case because he's done anything but maintain silence about it. He has made a number of statements that certainly give his side. I'd like to hear it all. He's talked to friends and employees. He's communicated to the press. He's communicated to his lawyers to the Justice Department regarding the Office of Professional Responsibilities review of his actions while he's a government employee in the Office of Legal Counsel. Apparently the only people who have not explained his actions to are the people who granted him a lifetime appointment to the federal bench, American people through their elected representatives in the Senate. So how we approach mistakes of the past, whether we choose to learn from them, is going to shape our way forward. Accountability can help restore our reputation around the world. But we have to restore the trust of the American public in our government. I'm a proud American. I think all Vermonters are. I'm proud of our history of this country. I'm proud of the times when our country has upheld the rule of law. I'm also proud of the fact that the United States of America, when it's made mistakes, has not been afraid to admit those mistakes and learn from them and pledge not to make the same mistakes again. That's why we have this hearing. And that's why the American people deserve to know what mistakes were made and what we intend to do about it. So, Senator Whitehouse, I applaud you for holding this hearing. I think it's one of the most important hearings the Senate Judiciary Committee will hold this year.
Thank you, Chairman. The distinguished Chairman of the Senate Intelligence Committee and a member of the Judiciary Committee, Senator Feinstein.
Thank you very much, Mr. Chairman. I would echo the Chairman's words. Thank you for your leadership for holding this hearing. Last month, the Obama administration released 4 memoranda from the Office of Legal Counsel, and questions have circulated ever since. Now, it is well within the Judiciary Committee's jurisdiction to review these opinions and make findings as to whether the committee does feel they fall within existing law, as well as international treaties and conventions to which the United States is a signatory and therefore bound. I listened very carefully to what Senator Graham said. I do not agree. I agree that the prior administration made the judgment that they did not apply, but that judgment was repudiated in Supreme Court decisions, and as I read them, the finding was that those conventions do, in fact, apply. But as was the case with the program for warrantless surveillance, access to these legal opinions were severely restricted for years. It has been publicly reported that the Office of Professional Responsibility may soon recommend to the Attorney General that the authors of these legal opinions face certain sanctions. However, the specifics of the OPR report have not been released. While the Department of Justice can and should review the performance of its employees, the Judiciary Committee does have the responsibility of independent oversight of the Department of Justice and how it interprets the Constitution and the law, just as the Intelligence Committee, which I chair, has the oversight jurisdiction of the 16 intelligence agencies. As members know, the Intelligence Committee is exercising its oversight responsibilities. We are conducting a major review of the CIA detention and interrogation program. This will include a detailed review of the conditions of detention experienced by high-value detainees at black sites, more than 24, how interrogation techniques were applied, by whom, in what combination, over what period of time, what information was produced as a result of these interrogations, and whether such information could have been obtained through other means. An evaluation of whether, in fact, the CIA detention and interrogation program complied with or exceeded the OLC opinions and other policy guidance, and whether the Intelligence Committee was accurately briefed about the detention and interrogation program and given a full explanation of what was happening at certain sites around the world. I believe this particular point is very important considering our review responsibilities. All of the facts will then be placed before the committee, and the committee will then work its will. Now, this to do right is a major undertaking. It involves months of review. It involves going through millions of unredacted papers, documents, cables, and emails, and a substantial number of personal interviews. The work will necessarily be classified in order to get the full scope of what has happened. And the work will be done fairly and professionally and in a strong bipartisan manner. And I want to stress that. Yesterday, I had a brief meeting with Mr. Soufan, who is going to shortly be before this committee. He will be asked at the right time, when we have the facts, to come before the Intelligence Committee. Now, we have 6 crossover members that sit on this committee and on intelligence, including Senators Whitehouse, Feingold, Wyden, Hatch, Coburn, and myself. So I am convinced that between the Intelligence Committee's review and study and the Judiciary Committee's oversight of DOJ and these opinions, that we will be able to provide a substantial body of knowledge and work within which judgments and assessments can be made. I very much hope that this will be the case. I think to make this an explosive issue without carefully laying out all of the facts, conditions, cables, directives, and the whole situation will be a big, big mistake. So I want to thank you, Mr. Chairman, and I certainly welcome your hearing, and the Intelligence Committee will welcome whatever evidence it might provide for our deliberations as well. So thank you.
Thank you, Madam Chair. And as somebody who's seen firsthand your work on the Intelligence Committee, I'm very proud of it and look forward to supporting you in that effort.
Thank you very much. Appreciate that.
Senator Feingold, do you wish to make a brief opening statement?
Very brief, Mr. Chairman, and I know we want to get on to the hearing, but this hearing is such an important step in shedding light on one of the worst abuses of the past administration. Let me be clear, this so-called enhanced interrogation program was illegal. It was contrary to our national values, and it undermined our national security. Like Chairman Whitehouse and Chairman Feinstein, I am a member of the Intelligence Committee, and I can tell you that nothing I have seen, including the 2 documents to which former Vice President Cheney has repeatedly referred, indicates that the torture techniques authorized by the last administration were necessary or that they were the best way to get information out of detainees. So clearly, the former Vice President is misleading the American people when he says otherwise. Mr. Chairman, I support further declassifications, including the rest of the Justice Department memos and letters on this program, the Inspector General report, and the work of the Intelligence Committee, provided their release would not jeopardize national security. And I've also sought the declassification of my own correspondence, which I sent to then CI Director Hayden, detailing my clear opposition to the program. While the revelations of the past month are uncomfortable for some, they are absolutely essential if our country is to return to the rule of law. I am pleased that the members of the Judiciary Committee and the Intelligence Committee are moving forward to determine exactly what happened, and I continue to believe that an independent commission of inquiry, as the Chairman Leahy has proposed, is needed so that we can fully understand and come to terms with this dark chapter in our recent history. Thank you, Mr. Chairman.
Thank you, Senator Feingold. And just to chime in on that point, I think it's clear that I also agree that the time will come when it frankly becomes inevitable that a nonpartisan authoritative commission should take a look at the work of Senator Feinstein's investigations, the OPR opinions, what the Judiciary Committee does under the leadership of Chairman Leahy, and other factors, and draw it all together so that the American people can make the appropriate conclusions. Now, our first witness is David Lubin. Professor Lubin is a leading expert on legal ethics. He has written numerous articles and books on the subject, including Legal Ethics, a leading textbook on the subject, and Legal Ethics and Human Dignity, which collects selected essays he's written on legal ethics during the last 20 years. He is the University Professor of Law at Georgetown University Law Center, where he has taught since he joined the faculty of Georgetown University Law Center in 1997. He has previously taught at the University of Maryland, Yale, and Kent State universities. He holds a PhD from Yale University and a BA from the University of Chicago. Professor Lubin's recent research interests have included the legal ethics implication of U.S. torture policy and the powers granted to the President by the Constitution. As a result, he's particularly well suited to evaluate the OLC memos and explain the ethical issues that they raise. Professor Lubin.
Thank you, Mr. Chairman. Chairman Whitehouse, Ranking Member Senator Graham, Chairman Leahy, and distinguished members of the committee.
Professor Lubin, let me say one thing quickly because you're our first witness. I'd like to try to keep all of the witness statements here, some of them are quite lengthy on paper, to 5 minutes. And so at some point, witnesses are going to start hearing this noise. which is your warning that the 5 minutes has run out, and if you could please wrap it up. And if you extend too far beyond it, I'll simply cut you off so that everybody has a fair chance and so that the senators have a chance to engage in dialogue, which is the most helpful part of a hearing.
I may go a minute or so over. Thank you for inviting me to testify today. You've asked me to talk about the legal ethics of the torture and interrogation memos written by lawyers in the Office of Legal Counsel. Based on the publicly available sources I've studied, I believe that the memos are an ethical train wreck. When a lawyer advises a client about what the law requires, there is one basic ethical obligation: to tell it straight, without slanting or skewing. That can be a hard thing to do if the legal answer isn't the one the client wants. Very few lawyers ever enjoy saying no to a client who is hoping for yes. But the profession's ethical standard is clear. A legal advisor must use independent judgment and give candid, unvarnished advice. In the words of the American Bar Association, a lawyer should not be deterred from giving candid advice by the prospect that the advice will be unpalatable to the client. That is the governing standard for all lawyers, in public practice or private, but it's doubly important for lawyers in the Office of Legal Counsel. The mission of the OLC is to give the President advice to guide him in fulfilling an awesome constitutional obligation, to take care that the laws are faithfully executed. Faithful execution means interpreting the law without stretching it and without looking for loopholes. OLC's job is not to rubber stamp administration policies, and it is not to provide legal cover for illegal actions. No lawyer's advice should do that. The rules of professional ethics forbid lawyers from counseling or assisting clients in illegal conduct. They require competence, and they demand that lawyers explain enough that the client can make an informed decision, which surely means explaining the law as it is. These are standards that the entire legal profession recognizes. Unfortunately, the torture memos fall far short of professional standards of candid advice and independent judgment. They involve a selective and in places deeply eccentric reading of the law. The memos cherry-pick sources of law that back their conclusions and leave out sources of law that do not. They read as if they were reverse-engineered to reach a predetermined outcome: approval of waterboarding and the other CIA techniques. Now, my written statement goes through the memos in detail, Mr. Chairman. Let me give just one example here of what I'm talking about. 26 years ago, President Reagan's Justice Department prosecuted law enforcement officers for waterboarding prisoners to make them confess. The case is called United States versus Lee. 4 men were convicted and drew hefty sentences that the Court of Appeals upheld. The Court of Appeals repeatedly referred to the technique of waterboarding as torture. This is perhaps the single most relevant case in American law on the legality of waterboarding. Any lawyer can find the Lee case in a few seconds on a computer just by typing the words water torture into a database. But the authors of the torture memos never mentioned it. They had no trouble finding a case where lawyers didn't call harsh interrogation techniques torture. It's hard to avoid the conclusion that Mr. Yu, Judge Bybee, and Mr. Bradbury chose not to mention the Lee case because it casts doubt on their conclusion that waterboarding is legal. Without getting further into technicalities that, quite frankly, only a lawyer could love, maybe not even a lawyer, only a professor could love, I'd like to mention briefly other ways that the torture memos twisted and distorted the law. The first Bybee memo advances a startlingly broad theory of executive power, according to which the president, as commander-in-chief, can override criminal laws. This was a theory that Jack Goldsmith, who headed the OLC after Judge Bybee's departure, described as an extreme conclusion that, quote, has no foundation in prior OLC opinions or in judicial decisions or in any other source of law. Quote, close quote. It comes very close to President Nixon's notorious statement that when the president does it, that means it is not illegal, except that Mr. Nixon was speaking off the cuff in a high-pressure interview, not a written opinion by the Office of Legal Counsel. The first Bybee memo also wrenches language from a Medicare statute to explain the legal definition of torture. The Medicare statute lists severe pain as a symptom that might indicate a medical emergency. Mr. Yu flips the statute and announces that only pain equivalent in intensity to organ failure, impairment of bodily function, or even death can be severe. This definition was so bizarre that the OLC itself disowned it a few months after it became public. It is unusual for one OLC opinion to disown an earlier one, and it shows just how far out of the mainstream Professor Yu and Judge Bybee had wandered. The memo's authors were obviously looking for a standard of torture so high that none of the enhanced interrogation techniques would count. But legal ethics does not permit lawyers to make frivolous arguments merely because it gets them the results they wanted. I should note that on January 15th of this year, Mr. Bradbury found it necessary to withdraw 6 additional OLC opinions by Professor Yu or Judge Bybee. Mr. Chairman, recent news reports have said that the Justice Department's internal ethics watchdog, the Office of Professional Responsibility, has completed a 5-year investigation of the torture memos. OPR has the power to refer lawyers to their state bar disciplinary authorities, and news reports say they will do so. I have no personal knowledge about what OPR has found. Presumably, investigators were looking either for evidence of incompetence, evidence that the lawyers knew their memos don't accurately reflect the law, or evidence that the process was short-circuited. This morning, I have called the torture memos a legal train wreck. I believe it's impossible that lawyers of such great talent and intelligence could have written these memos in the good faith belief that they accurately state the law. But what I or anyone else believes is irrelevant. Ethics violations must be proved by clear and convincing evidence and not just asserted. That sets a high bar, and it should be a high bar. In closing, I would like to emphasize to this committee that when OLC lawyers write opinions, especially secret opinions, the stakes are high. Their advice governs the executive branch, and officials must be told frankly when they are on legal thin ice or crossing over into unlawful conduct. They and the American people deserve the highest level of professionalism and independent, let me emphasize independent judgment, and I am sorry to say that they did not get it here. Thank you, Mr. Chairman.
Thank you, Professor Luban. One of the perils of Senate hearings is votes that happen. And a vote has just happened.
Oh, my God.
And what I will do is recess the hearing for 5 minutes to give us a chance to vote. People usually take longer than that, but I will be back immediately to call the hearing back into session. And if other people need to take a little bit more time, it'll be underway, and we're glad to have you come back. But for now, the hearing is temporarily adjourned so that we can vote.
This Senate hearing in a break now. A Senate hearing today on detainee interrogation tactics used in the Bush administration. Sheldon Whitehouse of Rhode Island chairing the Judiciary Subcommittee on Administrative Oversight. A recess, short recess now, so senators may vote on the floor today in the Senate. In fact, right now, a procedural vote on the nomination of David Hayes to be the Deputy Secretary of the Interior. Later, the Senate continues work on a bill to overhaul credit card regulations. The Senate hearing that's you're watching, that's been underway for just over a half hour today, the Associated Press reporting on it, saying that a Senate committee hears today from a former Bush administration official who argued against the use of harsh interrogation tactics. The one-time aide to Condoleezza Rice wrote a memo calling such policies illegal. That memo was part of internal arguments pitting the State Department against the Justice Department and then Vice President Dick Cheney. Philip Zelikow recently wrote on Foreign Policy magazine's website that the White House tried to collect and destroy every copy of his memo. House Majority Leader Steny Hoyer says investigations of harsh interrogation techniques should also include what Speaker Nancy Pelosi knew of the methods being used. Mrs. Pelosi insists she never was told about actual use of such methods in a 2002 briefing. Republicans are charging that Democrats knew of the tactics but did not protest. Again, that an Associated Press story talking about the hearing we're covering today here on C-SPAN 3. As this hearing is in a break, we're going to show you President Obama from just a short time ago. He said that Democratic leaders in Congress have committed to passing health care